Hi everyone, my name is Tumwebaze Edith Ananda. Welcome to our second series, Business in Uganda Post-Coronavirus. I'm going to be discussing arrangement and compromise, but before, I would like to take 2 seconds for everyone who is watching to like and subscribe to our channel. Thank you very much. Well, we are going to be discussing arrangement and compromise as a business rescue mechanism for any companies out there or businesses that are facing, that have financial obligations that they haven't been able to meet. Basically, the objective of arrangement and compromise is for the company and its creditors to come to an agreement on how they can rearrange or restructure the terms of the company's liabilities. So what happens is the first thing that has to happen here is that the company has to agree with the creditors to enter into an arrangement or compromise. The objective behind arrangement and compromise is basically for the company and its creditors to come to an understanding on how to restructure the terms of the liabilities. This can be by way of reduction of the amount that is due. For example, the creditors can decide to reduce on the liabilities of the company's debts. Yeah, but then this also involves a company actually restructuring its governance, restructuring the way it does its business so that it can be able to meet its financial obligations. The first thing that has to happen here is that the company and the creditors apply to court for this order. It can be a court, any court of competent jurisdiction, and the court, after issuing the order, the company will go ahead and have a meeting with its creditors on how the company can actually change its governance, all the different things that can be done by the company for it to raise money to pay the creditors. Yeah, so this is basically arrangement and compromise. Compromise basically means that the creditors may have to compromise, yes, or may have to reduce on the debt, or may have to reduce on the financial obligations that are owing to the company. So that's basically it for arrangement and compromise. The option for arrangement and compromise is available to both individuals, businesses, and companies. So I'm going to first take you through the legal process of a company and then take you through the legal process of an individual. So for a company, what happens is that the first thing the company has to do is agree with the creditors on whether or not they are going to take up arrangement and compromise as a legal option. And once this is agreed, the company will then petition any court of competent jurisdiction to issue this order. So once the court issues an order, the creditors and the company can therefore go ahead and discuss the different ways to restructure the company or find ways of the creditors compromising on their debt so that they can come to understanding on how the company can pay the debt. Where a company is under this legal process or under arrangement and compromise, they cannot undergo liquidation, they cannot undergo insolvency proceedings, and there cannot be any charge on their property or their assets. So this is a safe way for companies to actually revive themselves or stand on one foot as they revive their financial obligations to their creditors. All this information can be further gotten under Section 234, 235, and 236 of the Companies Act. The individual will apply for an interim order. This is found under Section 19 of the Insolvency Act. So once the individual applies for an interim order, the court must establish firstly that the individual has a licensed insolvency practitioner to supervise their assets and to basically handle their financial obligations. The court, when establishing all these things, will go ahead and issue the interim order. So when the court issues an interim order, the individual or the business is protected from bankruptcy proceedings or any charge against their property. Yeah, so this can be a safe way for a business or an individual that are not companies to actually also revive themselves from these financial obligations. The legal process for an individual can be found under Section 119 to Section 126 of the Insolvency Act. Yeah. So the other option that is available to a company under financial distress is receivership. Receivership basically is a process where the court appoints a receiver or someone to take over the company's assets and the company's income so that the company can be able to pay off its creditors. So what happens here is that this receiver is in charge of any salaries, any income that belongs to the company will go instead to the receiver, and the receiver will find a way to divide it amongst the creditors. This option is basically is mostly available to secured creditors. Secured creditors are creditors who have security in case the debtor, who is the company, has failed to pay. So where there's a secured creditor and there's a company, for example, banks, whenever you're taking out a loan from a bank, you have to give what they call a security. It can be land, it can be any asset that you have that is equal to this amount. So basically, this is what, so when the company is unable to pay its debts, the receiver will come in to help these secured creditors get their money, for example, by selling the land or by selling any assets of the company. This can be a way this can be a solution companies can use to revive themselves during these tough times caused by the COVID-19 pandemic. Thank you very much. I hope my video has been informative. You can please don't forget to like and subscribe. Post in the comments for any questions you have or any topics that you would want us to discuss, and we'll definitely read them and get back to you. Thank you so much. We are the Uganda Society for Legal Academics. Bye.